Let's get Terry Muran. What have we learned, Terry?
David, it's over. The long constitutional debate on whether gay couples have a constitutional right to marry is over, and the answer is yes. In every state in the United States, as of now, gay couples have a constitutional right to marry. A 5-4 decision from the United States Supreme Court, written by Justice Anthony Kennedy, finding that the 14th Amendment requires every state to open their marriage laws to gay couples and requires every state to recognize the gay marriages that are performed in other states. It's an opinion, just looking at it briefly, that is filled with what you might call romance, a sense of the abiding connection that couples have regardless of their gender. And let me just give you a very brief example. Justice Kennedy, once again, writing with the liberals, and this is about the third or fourth major gay rights decision from Justice Anthony Kennedy. He says the nature of marriage is that through its enduring bond, two persons together can find other freedoms, such as expression, intimacy, and spirituality. And he says that essentially it is a fundamental right of couples to have their marriages recognized because the Constitution's guarantee of equal protection of the laws. Right above that building behind me, it says equal justice under law. That principle, Justice Kennedy and 4 other justices say, means that the United States is now a nation where gay people can get married.
And Terry, this is significant because the Supreme Court seems to have gone further than they had to here. They could have, if they had wanted to, simply said that states have to acknowledge marriages that occurred in other states. But they went further here in this 5-4 decision.
Absolutely, David. They did have that halfway point they could have gone, which is states continue to have the laws you want, but if another state allows gay marriage, you have to recognize that marriage as well. Justice Kennedy going beyond, as you got the sense he wanted to a couple of years ago in the case about California Proposition 8 and the Defense of Marriage Act. And here's why. He's always been sensitive to the loss of dignity and the stigmatizing that he says denying gay couples the right to marry imposes. He says here excluding same-sex couples from marriage conflicts with the central promise of the right to marry. Without that recognition, he says, stability and predictability of marriage, their children suffer the stigma of knowing their families are somehow lesser. Again and again, we've heard about the children from Justice Kennedy, the children of families of same-sex couples across the country. He has been concerned in his writings and in the oral arguments about what denying the right to marry to gay couples does to the children. And here, once again, in hard American law, we hear about the families that are everywhere in communities around us that now have an equal status in marriage in every state in the country.
Profound, Terry.